Malaysia's Islamic banking industry is one of the most advanced in the world, operating under a dual banking system that combines modern financial practices with Sharia principles. Every day, banks and customers enter into Islamic financing agreements with each other. When these agreements arise over payment defaults, contractual obligations, or Sharia compliance, it can develop into complex disputes which requires to be resolved through court litigations or through arbitration centers, where specialized arbitrators with expertise in Islamic finance can provide a binding decision in a more flexible and confidential setting. But which mechanism is more effective in ensuring Sharia compliance, legal certainty, and commercial practicality?
Good day everyone. Our presentation today is titled Dispute Resolution Mechanism, a comparative analysis between court litigation and arbitration in Islamic banking disputes. Islamic banking has become one of the fastest growing sectors in Malaysia's financial industry. Unlike conventional banking, Islamic banking must comply with Sharia principles, which prohibits elements such as riba, interest, gharar, which refers to uncertainty, and maisir, which refers to gambling. As Islamic banking transactions become more complex and widespread, disputes inevitably arise between financial institutions and customers. These disputes commonly involve issues such as financing agreements, defaults in payment, contractual obligations, and compliance with Sharia principles. Because Islamic banking combines both legal and religious considerations, resolving disputes becomes more challenging than in conventional banking. Any dispute resolution mechanism must therefore ensure compliance not only with civil law but also with Islamic principles. In Malaysia, there are two primary methods used to resolve Islamic banking disputes. The first is court litigation, where disputes are heard before the civil courts with guidance from the Sharia Advisory Council or SAC. The second is arbitration, a form of alternative dispute resolution where parties submit disputes to independent arbitrators who issue binding decisions. Throughout this presentation, we will compare these two mechanisms by examining their legal framework, advantages, limitations, efficiency, Sharia compliance, and overall effectiveness in resolving Islamic banking disputes.
Building on that overview, let's take a look at the court litigation. So court litigation remains the primary mechanism for resolving Islamic banking disputes. And although these disputes concern Islamic finance, they are heard by the civil courts, namely the High Court, Session Court, and the Magistrates Court. This is because banking, finance, and commerce falls under the federal list of the Federal Constitution under the 9th Schedule. In addition, banks are corporate entities, whereas the jurisdiction of Sharia courts is generally limited to persons professing. Nevertheless, Islamic banking disputes must comply with both civil law and Sharia principles. A key institution involved in this process is the Sharia Advisory Council, also known as SAC, which was established under the Bank Negara Malaysia. The SAC serves as the highest authority on Sharia matters relating to Islamic finance, and it plays a very important role in ensuring that Islamic banking and takaful products remain Sharia compliant. Under the provisions of Section 56 and 57 of the Central Bank of Malaysia Act 2009, whenever a Sharia issue arises during court proceeding, the court must either refer to existing SAC ruling or seek a ruling directly from the SAC. These rulings are binding on both courts and arbitrators. So the significance of the SAC was clarified in the federal court case of JRI Resources Sendirian Berhad against Kuwait Finance House Malaysia Berhad. The court held that judges must first determine whether a genuine Sharia issue arises. If an applicable SAC ruling already exists, the court must apply it. Otherwise, the matter must be referred to SAC. Importantly, the SAC only determines the relevant Sharia principles, while the judge remains responsible for deciding the dispute based on the facts and the law of the case. Despite this framework, concerns have been raised regarding the ability of some civil court judges to deal with complex Islamic finance matters. In the past, certain judges viewed referrals to the SAC as an unjustified surrender of judicial authority, leading to inconsistent approaches. A notable example is the case of Afin Bank Berhad against Zulkifli Abdullah, where the court recalculated the amount payable under an Islamic finance agreement by excluding unearned profit. The decision generated significant debate, and it highlights the concern regarding the specialized expertise required in Islamic finance case. Litigation offers several advantages. Firstly, the court judgments are legally binding, enforceable, and it contributes to legal certainty to the development of judicial precedents. However, litigation can also be costly and time-consuming. Furthermore, the technical nature nature of fiqh muamalah may present challenges for judges who do not possess specialized knowledge in Islamic finance. While litigation remains the traditional method for resolving Islamic banking disputes, it is not the only avenue available to parties. In recent years, arbitration has emerged as an increasingly attractive alternative due to its flexibility, confidentiality, and specialized expertise. Let us now examine the arbitration framework in Malaysia.
Arbitration is one of the most widely used alternative dispute resolution mechanisms worldwide. Unlike litigation, arbitration involves an impartial third party whose decision is legally binding on the disputing parties. In Malaysia, arbitration is governed primarily by the Arbitration Act 2005 and the rules of the Asian International Arbitration Centre (AIAC). In disputes involving Islamic finance transactions, any Sharia issue must be referred to the Sharia Advisory Council (SAC), or the tribunal must consider SAC's published rulings. The SAC serves as the highest authority on Sharia matters relating to Islamic banking and finance disputes in Malaysia. The AIAC also introduced the I-arbitration rules, which specifically caters to disputes arising from Sharia-compliant financial transactions. Under Rule 38 of the I-arbitration rules, the arbitral tribunal may refer to Sharia questions to relevant Sharia counsel or an expert for a ruling, while the tribunal remains responsible to determine the facts and issuing the final award. Moving on to Indonesia, Islamic arbitration is conducted through the National Sharia Arbitration Board, or commonly known as the Basharnaras. Similarly to Malaysia, it focuses on resolving disputes through deliberation and amicable settlement. However, Basharnaras only acts upon formal requests and generally aims to resolve disputes within a 6-month time period. It is undisputed that arbitration offers several advantages. It ensures that disputes are resolved according to Islamic principles, promotes a more cooperative win-win outcome, and also experts such as the SAC are allowed to provide specialized guidelines on complex Sharia issues. However, there are also disadvantages. Arbitration can be costly due to arbitrators' fees and experts' expenses. There are procedural inconsistencies between different legal frameworks, and the effectiveness of the process depends heavily on the arbitrator's impartiality. Furthermore, enforcement of arbitral awards may be difficult in jurisdictions that adopt different interpretations of the Sharia principles. Arbitration, however, remains an important mechanism in Islamic banking because it combines the legal enforceability of Sharia compliance, although several practical challenges still needs to be addressed.
Having discussed both mechanisms separately, we will now compare them. A major challenge in Islamic banking dispute is ensuring consistent Sharia compliance. In litigation, the SAC helps maintain consistency by providing authoritative rulings on Sharia issues. Judicial precedents also contribute to legal certainty. However, cases such as Affin Bank and Arab Malaysian Finance demonstrate that courts have sometimes interpreted Islamic finance contracts differently, leading to concerns about inconsistency. Arbitration offers a different approach. Parties can appoint specialists with expertise in Islamic finance and Sharia law. However, arbitral tribunals are not strictly bound by judicial precedents. As a result, different arbitrators may adopt different interpretations of similar Sharia issues. Another important comparison concerns speed, cost, and confidentiality. Litigation generally involves more formal procedures, multiple hearings, and appeals. This often results in delays and increased costs over time. Arbitration is usually fastest because the parties have greater procedural flexibility and can avoid lengthy appeals. Regarding confidentiality, court proceedings are generally open to the public. Arbitration proceedings, however, remain private and confidential. This makes arbitration particularly attractive for financial institutions that wish to protect sensitive commercial information.
Beyond these differences, enforceability and future reforms must also be considered. Hence, the final aspect of comparison today would be between enforceability and overall effectiveness. Under court judgment, they enjoy strong domestic enforceability because they are issued directly by Malaysian courts and can be enforced through the judicial system. However, for arbitration, they are also considered binding, in which one advantage that they enjoy is that they can be recognized internationally through the New York Convention, which makes arbitration especially suitable for cross-border Islamic finance transactions involving foreign investors and multinational corporations. Nevertheless, enforcement still persists and challenges may arise when different countries adopt different interpretation of Sharia principles. An example of this would be when an Islamic finance product is recognized in Malaysia, they may not be necessarily accepted elsewhere outside from Malaysia. Hence, to strengthen the effectiveness of both dispute resolution mechanisms, several reforms may be considered. Firstly, there must be a greater judicial training in Islamic finance and fiqh muamalat to be introduced to this judge so that the judge expertise in this area would be greatly improved and enhanced. Next, Malaysia may also consider establishing a more specialized Islamic finance court or division to handle these disputes more effectively and efficiently. Thirdly, there must be a clearer and more harmonized Sharia standards to be developed at both domestic and international levels alike. And last but not least, arbitration procedure should be further standardized to reduce uncertainty and improve consistency. Hence, through these reforms, it would help litigation and arbitration to be enhanced while also ensuring that Islamic banking disputes are also resolved fairly, efficiently, and in accordance with Sharia principles. To conclude, the comparison between that both litigation and arbitration does offer distinct advantages and face their own challenges and limitations. Therefore, rather than viewing one mechanism as superior to the other, it is necessary, imperative, and pivotal to assess how both contribute to Malaysia's overall Islamic banking dispute resolution framework.
In conclusion, both litigation and arbitration play important roles in resolving Islamic banking disputes in Malaysia. Litigation offers strong legal certainty, enforceability, and consumer protection through the authority of the courts and oversight by the SAC. However, it may be time-consuming and may involve judges who lack specialized expertise in Islamic finance. On the other hand, arbitration provides flexibility, confidentiality, and specialized expertise, making it particularly suitable for complex and international Islamic finance disputes. Nevertheless, arbitration may involve higher costs and challenges relating to enforcement and differing Sharia interpretations. Therefore, neither mechanism can be regarded as superior to the other. Instead, Malaysia's hybrid dispute resolution framework successfully combines the strengths of both litigation and arbitration, balancing Sharia compliance, legal certainty, and commercial practicability. Thank you.